In general, contracts can be oral or in writing, but there are certain types of contracts that must be evidenced by a signed writing in order to be enforceable in courts of law. A statute of frauds is a law passed by a legislature that requires certain types of contracts to be in writing. One of the most common and confusing types of contracts that must be in writing are long-term contracts, generally defined as contracts that cannot be performed within 1 year from the making thereof. This lesson will explain when long-term contracts require a signed writing and when they don't. The general rule of contract law is that contracts that cannot be performed within a year from the making thereof need to be evidenced by a signed writing. Otherwise, they are not enforceable in courts of law. The rule that requires the signed writing in evidence of a long-term contract is called the 1-year provision in the Statute of Frauds. But there are exceptions to the 1-year provision of the Statute of Frauds. Such long-term contracts may be enforceable even without a signed writing, where one party to an oral agreement took some action in detrimental reliance of its counterparty's oral promise. This exception is known as promissory estoppel, or detrimental reliance. Two famous cases regarding long-term employment contracts will illustrate how the statute of frauds and promissory estoppel exception works. The first case is McIntosh versus Murphy, which was decided by the Supreme Court of Hawaii in 1970. The second case is Stearns versus Emery-Waterhouse, which was decided by the Supreme Court of Maine in 1991. The statute of frauds is a general term for a statutory law, a law passed by a legislature that requires a certain kind or kinds of contract to be evidenced by a signed writing. This does not actually require the contract itself to be in writing. Rather, it requires some written evidence of that contract's formation, signed by the party to be charged. The party to be charged means the party who is denying the existence or the enforceability of that contract. While this lesson will focus on one of the statutes of frauds, the 1-year provision, the promissory estoppel exception I'll discuss today applies equally to all statute of frauds issues. And you might remember the statute of frauds by the common acronym MYLEGS, which stand for some of the types of statutes of frauds you'll find in most jurisdictions. MYLEGS stands for contracts in consideration of marriage, contracts that cannot be formed within a year from the making thereof, contracts for the sale or transfer of an interest in land, contracts for an executor or administrator to take a duty of a decedent, contracts for sales of goods for more than $500, and contracts of suretyship, where one party gives assurance that it will cover the debts or obligations of another. All of those types of statutes of frauds are pertinent to this lesson about promissory estoppel, because promissory estoppel can be an exception to the requirement of a signed writing for all of the types of contracts subject to the statute of frauds. Since contracts are usually governed by state law, each state may have its own requirements for what contracts need to be in writing. Although there are some common types that exist in most American jurisdictions. Perhaps the two most common types of contracts that require a signed writing are contracts for sales of land and long-term contracts, which are usually defined as contracts that cannot be performed within 1 year, at least in most jurisdictions. A common statute of frauds for long-term contracts requires that contracts that cannot be performed within 1 year from the making thereof must be evidenced by a signed writing. For example, if a contract is made on January 1st, 2020, that contemplates some performance that cannot be complete until January 2, 2021, that contract is for more than a year, and, pursuant to the statute of frauds, it must be evidenced by a signed writing in order to be enforceable. That is, unless some exception to the general rule applies. A common law exception to the statute of frauds is technically known as enforcement by virtue of action in reliance. This doctrine is also called promissory estoppel, or detrimental reliance. This lecture will refer to this doctrine as promissory estoppel. The legal doctrine of promissory estoppel requires 4 things. First, a promise. Second, the promisor, which is the person who makes the promise, should reasonably foresee that the promise will induce action or forbearance upon the person who receives the promise, known as the promisee. Third, the promisee, the person in receipt of the promise, must actually take that action or forbearance. And fourth, justice must require enforcement of the promise. The first element of a promise is a fundamental concept in all of contract law. A promise is a manifestation, meaning some outward statement or action, not merely a privately held belief, of an intention to act or to refrain from acting in a certain way. A promise suggests a commitment has been made by the promisor, the person who made the promise, and it was made to the promisee, the person who hears the promise and reasonably expects to receive the benefits of that promise. The next 2 elements, whether it was reasonably foreseeable by the promisor that the promise would cause action or forbearance, and whether the promisee reasonably acted or refrained from taking action because of the promise, are relatively straightforward. I'll use a hypothetical for the next portion of this lecture to make this a little bit more concrete. For example, if Duquesne University promises Professor Orenberg that Duquesne will employ him as a law professor in Pittsburgh for 5 years, it's reasonable for Duquesne to expect this to induce Orenberg to quit his job in California, sell his house there, and move to Pittsburgh. It's even easier to determine, as a matter of fact, whether Orenberg actually moved to Pittsburgh. If Orenberg moves to Pittsburgh and Duquesne does not employ him, it's pretty clear that Orenberg is injured by the loss and sale of his house and job, and he has nothing to show for it. But injury alone does not imply an injustice has been perpetuated. When does justice require enforcement of Duquesne's promise? When can injustice be avoided only by enforcement of the promise? That is usually the most challenging aspect of determining whether the promissory estoppel exception to the statute of frauds applies. There are 5 factors or circumstances that are relevant to the analysis of whether injustice can be avoided only by enforcement of the promise, even though it's otherwise unenforceable because of the statute of frauds. We're going to next talk about the 5 factors in general, and then we're going to discuss each one more specifically. The first factor is the availability and adequacy of other remedies, particularly cancellation and restitution. The second is the definite and substantial character of the action or forbearance in relationship to the remedy sought. The third is the extent to which the action or forbearance corroborates evidence of the making and terms of the promise, or the making and terms are otherwise established by clear and convincing evidence. The fourth is the reasonableness of the action or forbearance. And the fifth is the extent to which the action or forbearance was foreseeable by the promissor. The first factor is the availability of other remedies, such as restitution. Restitution is a legal concept dating at least back to the 13th century. That means restoring some person to its original status. For example, if we can give Orenberg back his job at the law firm and his house in California, that would show there is some other remedy, namely restitution, that is available. If another remedy is available in this way, courts will be less likely to enforce the promise itself. In other words, if we can put Orenberg back in the position he was in before Duquesne made his promise, we might not make Duquesne keep its promise to employ him. The second factor is the definite and substantial character of the action or forbearance in relation to the remedy sought. In other words, how clear is the injured party's request of the court, and how obviously connected is that request to the promise itself? If Orenberg asked to either get the job he was promised or at least the salary he would have received, that's a request that's clearly related to the promise. But what if Orenberg instead asked to be compensated in cash value for the fame he would have enjoyed as a law professor at Duquesne? That's much less definite and less clearly related to the promise. Courts will be more likely to enforce the broken promise where there's an obvious link to the remedy requested. In this case, Orenberg is more likely to get the salary than the cash value of the fame. The third factor is the extent to which the action or forbearance by the injured party corroborates or proves the making of the promise, or whether there's other evidence showing that there's clear and convincing evidence of this promise being made. In other words, does the fact that the party took the action itself show that a promise was made to that party? The statute of frauds is a rule that serves to prevent one party from pretending a serious promise was made when it wasn't. So courts require a signed writing signed by the party to be charged, signed by the party denying the existence of such a promise, to prevent one party from thrusting an obligation on someone who never intended to take on that commitment. But where there is other evidence that the alleged promissor did in fact make such a commitment, then courts become more comfortable enforcing that obligation. When a party takes an action that doesn't make sense but for the existence of a promise, where Orenberg had no reason to leave California and move to Pittsburgh if not to work long-term at Duquesne, then the fact of that action will serve as evidence that the promise was made. Courts will be more willing to enforce promises, even where there is no signed writing, when some other means shows that the promissor clearly and convincingly made that promise to the promisee. The fourth factor is whether the injured party's action or forbearance was reasonable. This is a sort of objective test, meaning the court will ask what a reasonable person in the place of the promisee would have done. This is usually a matter of fact, and the court might ask the jury to determine what actions and reasons are reasonable or unreasonable. In this example, quitting one job to take another job is probably reasonable. But if Orenberg commissioned a large bronze statue of himself because he believed this job at Duquesne would make him so famous that his hometown would want to display a bust of this celebrated native, that is almost certainly unreasonable. Courts will only enforce promises that cause reasonable reliance, so the court would probably award damages for the losses from quitting the job, but not for any losses on commissioning a statue. The fifth and final factor is the extent to which the action or forbearance was foreseeable by the promissor. Should a reasonable person, in the position of the promissor, the person who made the promise, expect the promisee, the person who received the promise, to rely on that promise? This factor is similar to the previous one, as both ask what reasonable people would have expected in this situation. There's a general concept in the law of contract damages that a party should not be held responsible for unforeseeable harms. In a famous case, Hadley versus Baxendale, a delivery company agreed to ship a broken crankshaft from a mill that used the crankshaft to the factory that would repair it. The shipment was delayed, and the mill was closed down in the meantime. The mill sued the delivery company for the lost profits during the closure, and the court held that the delivery company should only be responsible for those losses if the closure was reasonably foreseeable. If most mills have a spare crankshaft, for example, so they can keep operating while one crankshaft is being repaired, then the delivery company should probably not be responsible for the delay, unless it actually knew that the mill only had one crankshaft. Likewise, here, courts will only hold a party responsible for the foreseeable consequences of its promise. In our example, it seems reasonably foreseeable to the university that a wannabe professor would quit his job in a law firm and move across the country to accept a long-term job as a law professor. Selling one house upon such a move is probably foreseeable too, but commissioning a statue is almost certainly unforeseeable, and for that reason likely would not be granted damages for that. In our simple hypothetical case, Duquesne University offered a 5-year teaching job to Professor Orenberg, and Professor Orenberg accepted the teaching job and then took some actions in Reliance. He quit his law firm job, sold his house, and relocated for work. Under these conditions, the promise is probably enforceable even without a signed writing, because it meets the factor test for promissory estoppel, an exception to the statute of frauds. That's exactly what happens in our first case, McIntosh v. Murphy, although we'll see the court arrives at a different result in the second case, Stearns v. Emery-Waterhouse. In the case of McIntosh v. Murphy, George Murphy owned Murphy Motors, an Oldsmobile dealership in Honolulu, Hawaii. I suppose there was a labor shortage in Hawaii because Murphy went to Southern California in March of 1964 to interview prospective managers for his car dealership in Honolulu. There he met Dick McIntosh and discussed the position of sales manager with him. About a month later, in April 1964, Murphy's general manager called McIntosh and told him the position was still possible. Later that April, McIntosh sent a telegram to Murphy to the effect that he would arrive in Honolulu on Sunday, April 25th, which admittedly was a little odd, since no formal offer of employment seems to have been made or accepted yet. Now, pay attention to these dates, as the contract formation date turns out to matter in this case. On Saturday, April 25th, Murphy called McIntosh and told him that the assistant sales manager position was still open. This was a lesser job title than originally discussed, and it was before McIntosh traveled to Honolulu. But it does appear to constitute an offer of employment, an offer for a contract. McIntosh then confirmed or accepted this contract, and he stipulated that he would arrive in Honolulu the next day. McIntosh would later claim that on this call, Murphy promised and guaranteed McIntosh employment until at least April 27th, 1965, a full year later, while Murphy claims he said nothing of the sort. McIntosh worked for Murphy for about 2.5 months until Murphy fired him on July 16, 1964, on the grounds that McIntosh was unable to close deals and couldn't train salespeople effectively. Remember that McIntosh claims Murphy promised to employ him at least until April 27, 1965, although the parties debated this point. McIntosh then sued Murphy for breach of the employment contract. He claimed that Murphy promised to employ him for at least a full year until April 27, 1965, and Murphy defended by arguing the contract was unenforceable because it was for more than 1 year of employment. Therefore, it could not be completed within 1 year from the making thereof and needed to be evidenced by a signed writing. Murphy argued the statute of frauds required this employment contract to be evidenced by a writing signed by Murphy, and there was no such writing. Murphy then argued that the trial court should dismiss the case. The trial court disagreed, but it did so by getting the law wrong, although it admittedly and candidly did so in order to avoid what it perceived as injustice to McIntosh due to Murphy's denial of their agreement. The trial court found that the contract was formed during the telephone call on Saturday, April 25th. But since that was a weekend, the court reasoned, work was not to start until the following Monday, April 27th, and therefore, the court wrongly reasoned, the contract was actually for exactly 365 days, from April 27, 1964 to April 27, 1965, which is exactly 1 year, not more than a year. Since the statute of frauds only requires a signed writing for contracts of more than a year, the trial court reasoned that no signed writing was required here, and therefore the employment agreement was enforceable, even though it wasn't evidenced by a signed writing. This is, of course, wrong as a matter of law. The statute of frauds in Hawaii at the time required a signed writing evidencing any contract that could not be performed within 1 year from the making thereof. The contract was made on April 25th, 1964, when the parties had a telephone conversation including offer and acceptance, and allegedly ran until at least April 27th, 1965, which is more than a year. Courts of law do not have the authority to rewrite or ignore statutory law in this way, so this was a clear legal error, regardless of the court's motivation to do justice in this case. Murphy appealed all the way up to the Supreme Court of Hawaii, who agreed that the trial court made a legal error, but surprisingly, still found the contract to be enforceable. How could this be? The contract could not be performed within a year of the making thereof, that's true, and it was not evidenced by a signed writing as required by the statute of frauds. But another principle applies to this case. That is the doctrine of promissory estoppel, which allows the court to enforce Murphy's promise by virtue of an action in reliance of that promise may apply to the facts of this case. Recall that there is a 5-factor test to determine whether justice requires a contract to be enforceable, even though it violates the statute of frauds because of the doctrine of promissory estoppel, also known as detrimental reliance. The Supreme Court of Hawaii's analysis of promissory estoppel on this matter is, quite frankly, unsatisfying. The court addresses the first factor in the most conclusory fashion. The court simply pronounces that injustice can only be avoided by enforcement of the contract and the granting of money damages. No other remedy is adequate. The plaintiff found himself residing in Hawaii without a job. It makes no effort to discuss why other remedies, such as restitution, are not available or adequate. One might presume that it was not possible to readily release McIntosh from his apartment lease in Hawaii or to return his sold possessions, although it seems easy enough to award him the monetary value of these things. The second factor is addressed somewhat more clearly. McIntosh requested payment in expectation damages of an amount equal to the difference between the 2.5 months that he was paid under the contract and what he would have received if he had been paid as allegedly promised for the full year, or for whatever term of work the jury would have found McIntosh and Murphy to have originally agreed on. The third factor is once again glossed over. The court implies that McIntosh's moving to Hawaii clearly corroborates that Murphy promised to hire him for a long duration and not merely at will. But surely people move for jobs even when they can be fired for underperforming at them. McIntosh's relocation evidences that a job offer was made and accepted, but it doesn't seem to be proof of a commitment by Murphy to keep McIntosh on for a year or more regardless of his performance at work. The fourth factor, McIntosh's reasonableness, is likewise not addressed in any depth by the court. Perhaps it's inherently reasonable for a person to sell one's possessions and take up residence in a foreign state in reliance of a promise of work there for a year or more. But there are facts here that might have given a reasonable McIntosh some pause. For example, the job title was demoted from sales manager to assistant sales manager, which implies perhaps that the term of the job has also declined from one of some permanence to an at-will position. More glaringly, however, is the total lack of any writing. Given that the law requires contracts to be in writing if they are of a more than a year term, and given that the purpose of such a requirement is to channel such long-term agreements into written form, was McIntosh truly reasonable when he sold all his belongings and moved to Hawaii on nothing more than an oral promise over a phone call to work as an assistant sales manager at a car dealership? The fifth factor is whether Murphy, the promisor, the person who made the promise of employment, reasonably should have expected McIntosh, the promisee, the person receiving the promise, to sell his things and relocate based on the alleged oral promise of long-term employment. This factor also seems debatable. The Hawaii Supreme Court pronounced, "There is no dispute that the action of the plaintiff in moving 2,200 miles from Los Angeles to Hawaii was foreseeable by defendant." But this is a bit of a straw man argument. Certainly the move was foreseeable. In fact, it was required to perform the job of a sales manager or assistant sales manager. But McIntosh could have put his things in storage, taken up month-to-month accommodations in Hawaii, and taken fewer actions in Reliance. That said, foreseeable is a lower standard than reasonable. Whether or not McIntosh's actions were reasonable, they were almost certainly foreseeable by Murphy. It seems then that the final factor, foreseeability, is the one on which the Supreme Court of Hawaii relies in finding justice for McIntosh in that case. Since Murphy should have reasonably foreseen his promise would cause McIntosh to act, the court finds that justice requires enforcement of that promise. There is a very well-reasoned dissent, however, that points out various flaws in the majority's logic. The dissent observes that the statute of frauds was enacted to avoid the consequences that this court is forcing upon the defendant, meaning that the purpose of requiring a writing is precisely to prevent one party from claiming the other made lofty oral promises for things like long-term employment and other such serious matters. Justice goes both ways, the dissent points out. While justice to the employee is one thing, justice to the employer is another. It is unusual to hire a sales manager upon just one in-person meeting and a handful of phone calls and telegrams for a term of a year or more, regardless of that person's performance in his role. To force Murphy to retain McIntosh, regardless of McIntosh's inability to close deals or train salespeople is itself a form of injustice. Moreover, it's a form of injustice that is precisely what the statute of frauds was designed to prevent. The dissent also provides a critical lesson in the balance of power under our constitutional system. If the statute of frauds is too harsh, as intimated by this court, and it brings about undue hardship, it is for the legislature to amend or repeal the statute, and not for this court to legislate. This lesson, while true, is also a bit of a straw man argument. In fairness to the majority, the court does not amend or repeal the statute of frauds in this case. The trial court did, but the Supreme Court did not. Rather, the Hawaii Supreme Court utilized a long recognized exception to the statute of frauds, namely promissory estoppel, albeit in a manner that the dissent obviously believes to be inappropriate. For those who are perturbed by the outcome in McIntosh v. Murphy, another very similar case that came out differently may be more appealing. The more recent case of Stearns v. Emery-Waterhouse Co. highlights the boundaries and limits of the doctrine of promissory estoppel in cases where the statute of frauds is violated. Emery-Waterhouse was a hardware store located in Portland, Maine. It first opened in 1842, and it was acquired by Ace Hardware in 2014. 30 years before that, in 1984, Emery-Waterhouse's president, Charles Hildreth, met with Timothy Stearns to discuss hiring him to run its hardware retail store. Stearns was currently managing a Sears Roebuck store in Massachusetts, where he earned about $99,000 a year, which is approximately $255,000 per year in the equivalent of 2021 monetary value. Although Stearns also owned property in Maine, showing he had some relation to that state. Stearns, who was 50 years old at the time, was somewhat dissatisfied with his job at Sears and was somewhat concerned about his job security there. In any event, he agreed to meet with Hildreth in Portland, Maine, where apparently Hildreth orally agreed to hire Stearns for what Stearns claim is a guaranteed salary of $85,000 per year indefinitely. The contract was never reduced to writing. Stearns resigned from Sears, sold his house in Massachusetts, and relocated to Maine, where he worked for nearly 2 years and received the specified salary. In December 1986, Hildreth was going to fire Stearns, but ended up merely demoting him to the position of National Accounts Manager and reducing his salary to $68,000 per year. Hildreth caused Emery-Waterhouse to later acquire a national marketing firm, such that the company no longer needed Stearns' services. So after 6 more months as accounts manager, Stearns was finally let go at the age of 54. Stearns sued Emery-Waterhouse for breach of contract, claiming that he was guaranteed permanent employment at $85,000 per year. Emery-Waterhouse moved for summary judgment on the basis that the contract was unenforceable because it violated the statute of frauds. At trial, the jury found there was an oral contract which was breached, and moreover that the oral agreement was unenforceable due to the promissory estoppel exception to the statute of frauds. In other words, the trial court and jury in Stearns v. Emery-Waterhouse came out the same way that the trial and Supreme Court did in the case of McIntosh v. Murphy. The case was appealed all the way up to the Supreme Judicial Court of Maine, where the decision was reversed. After a thorough discussion of the doctrine of promissory estoppel as a basis for avoidance of the statute of frauds, the court found that while promissory estoppel can, in some cases, be a reason not to require assigned writing, where otherwise required by the statute of frauds, such a conclusion would not serve the interests of justice in this instant case. How did these two cases, with such similar facts regarding an employee who detrimentally relied on the promise of long-term employment from an employer come to such different conclusions? While both courts seek to do justice, there seems to be a different focus in each of these cases. Whereas the McIntosh court focuses on the reasonableness of the plaintiff's reliance, the Emery-Waterhouse court seems to focus on the lack of wrongfulness by the defendant. The Emery-Waterhouse court effectively takes the opposite perspective that the McIntosh court did. The Emery-Waterhouse court finds that the defendant did nothing wrong, and so an equitable exception should not be levied against it. In fact, the plaintiff employee was fairly compensated for several years of work. The plaintiff employee neither proves nor alleges any fraud or bad conduct on the part of the defendant employer. And the Emery-Waterhouse court recognizes that the statute is primarily designed to protect people like the employer from such claims. And unlike the McIntosh case, which features a blistering dissent, the Emery-Waterhouse case was unanimously decided. Perhaps students will also feel more comfortable with one case than the other. However, it is still important to remember that the McIntosh decision and the equitable estoppel exception to the statute of frauds remains available to plaintiffs as a matter of law. It is not the preferred outcome. We always prefer a legal outcome to an equitable exception, but it may be appropriate to grant that equitable exception in certain cases, depending on the nature, for example, of the work or employment at issue. Although Emery-Waterhouse provides what is best understood as the general rule, there will always be exceptions like there was in McIntosh. For example, the Emery-Waterhouse court provides a rule that explains how the statute should be generally interpreted. An employee's preparations to begin a new assignment generally convey no direct benefit to the employer. So, in general, an employee's decision to relocate or otherwise prepare to become available for work shall not itself be a sufficient reason to avoid the statute of frauds. But there may be situations where the employee's preparations are directly beneficial to the employer. For an example of a potential exception to the general rule that preparing for work does not benefit the employer and therefore is not a basis for promissory estoppel, let's return to our hypothetical case of Duquesne University's offer to hire Professor Orenberg. If Duquesne University promises to hire Orenberg to teach contract law for 5 years starting in September, for example, it is reasonable for Orenberg and foreseeable to the university that Orenberg should spend the summer preparing to teach the course by reading casebooks and treatises, writing articles, creating slides, and perhaps even making videos on contract law for use on the university's learning management system. All these actions are a benefit to the university, and it will increase the quality of the education the university provides to its students. So this example might satisfy not only the McIntosh court, but also the seemingly higher standards of the Emery-Waterhouse court as a potential exception to the requirement that contracts for long-term employment must be in writing. In conclusion, the statute of frauds generally requires that certain classes of contracts need to be in writing, including, but not limited to, contracts that cannot be performed within a year from the making thereof. But to all these contracts, equitable exceptions apply to the statute of frauds. While such exceptions are rare, special factors can arise that require courts to enforce long-term contracts to the extent that justice so requires.